Now, here's how they self-identify. This is a big, huge survey that they filled out themselves. They self-identify. So this gives a little insight to them. They have a positive attitude, which is true. They are cooperative team players. Goes right back to everything being done in teams. No individuality. They're accepting of authority. Again, rules, 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 rules. And that accepting of authority depends upon the type of case you have. There are cases where someone who didn't follow the rules or didn't follow the authority of a supervisor, these people become very, they identify themselves as rules followers. They are the most supervised. They regard themselves as the most supervised generation ever, and they are. They're right about that. Next is they regard themselves as every generation in history as smarter than their parents. And they're smarter than everybody. And of course, this comes from the fact of having to show their grandmother, their parents, and their older siblings how to use a computer. So they're progressive. Again, this bodes well for the Democratic Party of the future because this is self-identification now. So they self-identify as progressive. Why? Because they've been raised in a world now, most of them have been raised in a world where the progressive issues, the issues of race, the issues of homosexuality, gay marriage, those sorts of things, these are very normal things for them. And they were raised with it being normal. And so they're very accepting. So they regard themselves as being on the cutting edge of everything. We are, and they are, because they're the first ones to know how to use the new technology, and then they teach it to us. They regard themselves as better educated, and I'm not sure this is true, because their education has become so packaged. I'm not sure they're as well educated as previous generations, but this is how they regard themselves. They think they're smarter, cutting edge, and better educated. And they regard themselves as global, which they certainly are because of the World Wide Web, obviously. So they interact with people around the world on the internet. So now, their near polar opposites are the boomers, who are their parents, and their older siblings. Now, here's something that's important for us. The Generation X was the consummate tort reform generation. And keep this in mind when you're looking at a jury panel. Generation X was raised with the idea that they think greedy trial lawyer is one word. And they were the ones that were there when all the TV ads were being run against us. And so they heard it every day. The millennials, first of all, many of their own members of their cohorts want a law degree, or they have a law degree. And they don't regard, since they are more progressive, and we, for the most part, are more progressive, they identify more with the trial lawyers, and they identify more with the good work that trial lawyers do because they are progressive. So as between the millennials and the Generation X, if you're worried about tort reform issues, be very cautious about Generation X, and you can be a little more forgiving of the millennials because they're more trustworthy from our viewpoint. Now, here are the 12 negative factors, events. You know, cohorts come from from common things that happen to a generation. And these are the negative events this is what formed their attitude about the world. And their attitudes about the world help form their beliefs, and their beliefs help form their opinions on how to decide lawsuits. So obviously 911, the .com failures, corporate corruption, and this is you see something here shaping up. You got a case against a corporation, you got a product liability case, you got a case against a big hospital, the whole big business institution. They see corporate corruption, a divided country. untrustworthy politicians. The Iraq and Afghan wars, the lack of security, their shrinking salaries, which is another thing. This generation is right now destined to be the first generation where their salaries are actually less than their preceding generation. Their average salary is going to be less than the Gen X folks. And they're shrinking opportunities. So again, when you're trying a case involving your individual plaintiff who now has been injured and he has less money to live on, he or she have shrinking opportunities for finding new employment, that sort of thing. These folks are saying, welcome to our world. Now you know what it's like to be a millennial. The outsourcing of jobs is a big event that took away their job. The insourcing of foreign workers has impacted them, and the downsizing. All these things have to do with their ability to find and keep a good job. And so again, your employee who's lost their job and is now, if you represent a person who's now 55 or 60 years old and they lost their job and now they're out there competing in this world, trying to find a job at the age of 50 or 55 or 60, then these folks can resonate to that because they're fresh out of college with a heavy debt and they can't find a job. And here's the reasons they can't find a job. Now, if you look at that list, the outsourcing of jobs, the shrinking opportunities, the insourcing of foreign workers, and downsizing, those are actions by whom? That's all corporate actions. So again, you have a whole body of jurors here who are anti-corporate by their very nature. They're anti-bank. They feel that they are personally being screwed by the banks because of the whole deal that was made about the government initially providing funding for education and all kind of government loans, and then they corporatize that and turn it over to the banks, and the banks are the ones that are still now bugging them about collecting on their student loans. So how do we communicate with them? Generically, you prime your information as in a news story. It's the who, what, when, where, and why, and then explain how. Who, what, when, where, why, and how. You sequence your story to show that you have proof to back up your allegations. They do not respond well to hyperbole, which is why I'm thinking about retiring. So when I talk about sequencing your story, you don't come in and start talking about your damages right off the bat. You don't come in and give a big spiel about damages on voir dire. You qualify them on damages on voir dire, and you set them up to explain what the damages are going to be that you're going to be talking about on opening statement. But you don't come in and prove up all your damages right off the bat, because these folks need to see that you can back up your allegations. So I think the way you sequence is you come in and you prove up your liability, but the allegations that you make on liability, the first things you do, in sequencing your evidence, you come in with hard evidence first, so that you're not just talking. It's not just you saying things. This is what happened. This is how it's going to be. These are the problems. You don't just start out talking about that. You come in with hard evidence first. Hard evidence is photographs, actual numbers, actual figures, things of that nature that are expert testimony that can provide hard evidence. You give them hard evidence as opposed to just your verbiage. And then after you prove this up for a while, prove up your damages, then and you prime your hard evidence of liability, then you can start talking about damages. Keep emotional appeals in their proper place and perspective, and sequencing damaging proof. Your damage proof wants to come. You want to come with what I call the Zeigarnik. Well, I don't call it, but it's a psychological principle, which is the Zeigarnik effect. And the Zeigarnik effect is to the effect that jurors, everyone, will cling most tenaciously to that which they discover on their own, as opposed to that which they are spoon-fed. So you want to sequence your damage proof in such a way that you start out, for example, in a brain injury case, you don't stand up on voir dire unless it's just really obvious to everyone. You don't stand up on voir dire examination and talk about this is irreversible, permanent irreversible brain damage. You start out talking about this is a head injury. It's a head injury case. And then you get into, later you get into injury to the brain. And then it's only after, as you put on more and more evidence, you want them to think, okay, it's a head injury case, okay, it's a serious head injury case, okay, wow, this is really serious. And then only after your doctor describes it as irreversible brain damage, then you talk about it in terms of irreversible. You want them to discover it's a head injury, this involves the brain. Oh, this seriously involves the brain. Wow, this is a serious irreversible brain damage. And you want you want them to discover that slowly and on their own, because then it becomes their discovery, not your spoon feeding. The next thing, plaintiffs should have a definite plan for rehabilitation, because they expect, if you're going to ask them to do something for you, and they've been trained to do this, if you want them to do something for you, their first question they ask is, really, what are you doing for yourself? So you show two things. You show what you are doing for yourself as a plaintiff, and then you show what you will do for yourself as a plaintiff if you have the money to afford it. You have a rehabilitation plan in place, but you need the financing for it. So you show a good use for the award. But and before you get to the courthouse, you need to think about these things. This is not something you think about the night before when you're trying to think, okay, what am I going to put in my closing argument? What good purpose will be served by an award of damages? Because we hear this all the time in focus groups. So, okay, so you've got a, yeah, it's a tragedy, you've got a dead child, but money's not going to bring the child back. So we hear that all the time. So you have to have an answer to what good purpose, and you make it part of your evidence as to what good purpose would be served by an award of damages. You explain how the money will improve the life of the plaintiff, actually improve it. Or the family, and if you have a breadwinner that's injured, the plaintiff and the plaintiff's family. Avoid a sense of entitlement. They resent entitlement because they work as a team. They don't think that one's more entitled than the other. So you don't ever discuss your client's damages in terms of entitlement. An award of damages in this case will help me to help myself to improve in the future. You're proving up three different scenarios. Number one is the life that the plaintiff was leading before the injury. So there's a test. Compared to what? Your condition today is this, but compared to what? It's so much better if you compare it to something. To come in and say, I'm hurting today, yeah, but how were you, compared to what? So you prove up what the plaintiff was doing, what the plaintiff's plans were, how they were physically, all the good things about the plaintiff's life before the tragedy. Then you prove their present circumstance. What is their condition today? And then the third thing you prove is what is their condition going to be in the future, and what's their life going to be like in the future as a result of the impact of this tragedy on them. Show that the plaintiff is self-motivated. The plaintiff has to have a plan and exhibit the plan of their self-motivation to improve. You're not just throwing yourself on the mercy of the millennials. You're seeking assistance, not a handout. Here's what I'm going to do for myself. I need help from you to do it. Avoid compensating the victim. We just avoid the use of the word victim because this is across the board with everybody. the whole victimization issue goes against us. So we don't talk about the victim. We don't use the word victim, I'm sorry. Prove that the plaintiff is both two things, in need and worthy of their help. So we can always prove, with the damages, we can always prove that our client is in need because they've been injured. But you have to prove they're worthy of their help. How do you prove they're worthy of help? You prove they're worthy of the help by talking in terms of how they have their own plan to do the best they can with what they have left, and what that plan is and how they're implementing that plan. It's worthy of their assistance, the assistance of the jury. It's not, here, I'm hurt, tell me, I want you to do everything for me. It's the operative word there is help. The next is personal responsibility is still the generic theme. It's the universal theme. It resonates across the board with every generation. I think it is the universal theme at the courthouse today. And you want to make, with whatever group you're dealing with, you want to make personal responsibility your issue. And you do that on voir dire examination before the defense has a chance to start ranting and raving about this is about personal responsibility. You can tell the jury that we invite you. We're going to invite you in this case to closely examine the conduct of the injured party. And the injured party, Ms. Jones, is fully accepting of any responsibility, her responsibility. As you see in this case, she has no responsibility because she did what you're supposed to do in her position. But if there is responsibility, she accepts it. The reason we're here today is because this defendant refuses to accept their responsibility for what they've caused by their negligent conduct. So make this your theme right off the bat.